On the record in the matter of the people of the city of Lansing versus John Vu, file number 23-01605, council appearance.
Assistant Public Defender John Lee on behalf of John View, who's in the courtroom and
Okay, Mr. Vu, today's the date that we reset your matter. It was scheduled for a hearing on a probation violation. Let's see. I know on April 22nd, when it was scheduled, Mr. Lee did not have discovery yet. Do you have the discovery now?
I do. Your Honor.
Okay, how are we proceeding today?
Mr. View is going to plead guilty as charged to the probation allegation.
That's correct, Mr. Vu?
Yes.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can put your hand down. Okay, Mr. V, you understand that you have the right in this matter to have a contested hearing on the violations?
Yes.
And you understand that you are being charged with the violations that you failed to report to probation back on February 28, 2024, and that you tested positive for abnormal creatine level 15.9 milligram at EverHealth on February 1st, 2024, and tested positive for alcohol with an ETG of 672 nanograms per milliliter at EverHealth on February 20th, correct?
Yes.
You understand that if you're found guilty or if you plead guilty, that your probation status can be revoked, or you can have your probation status extended. You can be sentenced to a term of jail time, or there can be other sanctions or oversight imposed for the violations. You understand that?
Yes.
Anybody threatening you to waive your right to a hearing today?
No.
Any promises being made to you if you waive your hearing?
No.
As to the violations that I just read, which is that you failed to report to probation on February 28, 2024, and you tested positive for abnormal creatine level and positive for alcohol in February 2024, how do you plead? Factual basis.
Thank you, Your Honor. Mr. View, did you plead guilty to impaired driving in this court in November of 2023?
Yes,
And then you were sentenced on that charge in January of 2024, correct?
I believe so. Yes.
And as part of that sentencing, you were ordered to complete a period of probation, correct?
Yes.
And as part of that probation, you were ordered to do certain things, including report to your probation officer and participate in random testing, correct?
Yes.
And you were participating in random testing because you were told to abstain or ordered to abstain from alcohol and marijuana and other drugs, correct?
Yes.
Okay. And so did you fail to report to your probation officer on February 28th, 2024?
Yes, I did.
Okay. And did you test positive for an abnormal creatine level on February 1st, 2024?
Yes.
And did you also test positive for alcohol at EverHealth on February 20th, 2024?
Yes.
No further questions.
Any questions from the city?
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find it to be made freely, voluntarily, and intelligently. Recommendation, which was dated prepared on March 5th, 2024, by your probation officer, indicates that you're scheduled to end your probation in October. This is the third technical violation. It says the recommendation is to continue your probation. Imposing jail time is not suggested. To add outpatient substance use 1 time per week to increase your testing for the next 30 days. It says defendant has not reported to probation since reading orders. Defendant had abnormal creatine level at first test and tested positive for ETG ETS. on February 20th, 2024. It also indicates that the substance use assessment recommends outpatient use counseling. Mr. Lee, you can address the court.
Thank you, Your Honor. Mr. View is a hardworking guy, works full-time over at Shift Group, pulling 10-hour shifts on a fairly regular basis. When he first started probation, he knew that he was expected to report, and he forgot, just outright forgot his first date. He reports that he did call in 2 days later and reported via Zoom at his regular day in March. He is solid on when he's supposed to report now. Told me that, yes, I report on the fourth Wednesday of every month and knows exactly what he's supposed to do. In regards to the creatine level, we're not really sure. He does work third shift, drinks a lot of coffee, and thinks that he may have diluted his sample somehow that way. But he admits to drinking alcohol. He was at a family event, one that honors the dead and only occurs every so often. And he admits that he slipped, he drank alcohol. And
So
he has
much.
expressed to me that, you know what, everything I've got going on in my life, including being a big part of my son's life, who's now 21 years old, is dependent upon me being available and ready for all things. So he wants to participate in outpatient counseling and get the help that he needs to be able to continue abstaining. So he humbly admits guilt and intends to cooperate and do whatever the court orders.
How is it that he forgot? How is it that you forgot that you were supposed to report to probation?
When I met with my probation officer, he told me the fourth Wednesday of every month, and that just slipped my mind.
And when did you remember?
When I finally remember, I gave him a call.
Have you been reporting since then?
Yes,
Okay. What about the victim impact panel that I ordered you to do within 90 days? What happened to that?
the community tech panel, I think my probation officer, he said just finish it before June.
My order says that you were supposed to attend victim impact panel within 90 days with verification. You reviewed that order?
I think that one was directed by my probation officer. He said,
What was my question?
yes, I reviewed.
Is this your signature?
I believe so.
Okay, so that indicates to me that you reviewed and signed that on January 25th, 2024, correct?
Yes.
What about my order changed? 'Cause the probation officer can't change my order. What did I tell you to do?
I did not know that. I'm sorry.
Why didn't you do it?
I don't know.
It's May. Have you started a victim impact panel?
No, I have not.
Why not?
And we've been pulling long shifts and I've just been tired.
Mr. Lee, are you tired?
Yes.
Mrs. O'Boyle, are you tired?
Yes.
Yes, it is my fault. I'm sorry.
When are you gonna get it done?
ASAP.
I'm gonna add substance abuse outpatient counseling at this time. Continue your probation. I want your victim impact panel completed within 30 days. Continue your probation at this time. You'll go downstairs and check in with your probation officer before you leave here today. Do you have any questions about my order?
No.
The probation officer can't change my order. If the probation officer says something different than what I say, you follow what I say, okay?
Okay.
Do you have any questions?
No.
Any additional matters for the record, counsel?
No, you're.
Thank you, you're all set. Looks like Ms. Walker. She's in my virtual courtroom.
Yes, Your Honor. I talked with Ms. Walker. She was confused. She thought her court date was tomorrow at 9:30 a.m. I explained to her that was inaccurate and asked her if she would be willing to appear this afternoon via Zoom and see if you would still see her.
Who is this back here? Sir, what's your name? Mr. Johnson. Mr. Johnson, okay, thank you. I need her file. the record in the matter of the people of the city of Lansing versus Kayla Janae Walker, file number 22-004610D, council appearance.
Andrew Boyle on behalf of the city, Your Honor.
This is the public defender John Lee on behalf of Kayla Walker.
Ms. Walker, can you hear us?
Yes, I can hear you guys.
Okay, today was the date that was set for a pre-trial for operating while intoxicated, 0.17 or higher. How are we proceeding on this?
Your Honor, I have had discussions with the city attorney who is requesting an assessment. The assessment that we have is dated. So I've instructed Ms. Walker that she's going to need to get a new assessment. And am forwarding her a list of providers today. She will schedule an assessment and get that completed before the next court date if the court is willing to adjourn.
Give me 30 days.
June 17th at 9:30.
June 17th at 9:30.
Okay, thank you.
No problem. This is a city case, so the city's cases before my courtroom are always on Mondays, okay? Tuesday
Okay.
would be a state case.
Okay, sorry about that mix-up. That was completely my fault.
No problem. We'll quash the warrant and we'll see you on June 17th.
Thank you
Any
very
additional
much.
matters for the record?
No, thank you.
You're all set.
Thank you.
You're welcome. All right, we're gonna put him on Zoom. Correct. I know. I'm gonna get my iPad. We're gonna put him on Zoom because the attorney's on Zoom.
Okay, I'm sorry.
No problem. Mr. Smith?
Good afternoon, Your Honor.
They'll show you what to do.
Good afternoon. We have Mr. Johnson in the courtroom. We'll get him on Zoom so you can do your, is this a motion or it's in?
Yeah, it's actually a motion and it's kind of an
Oh.
objection to a state income tax garnishment.
Got
So,
it. Okay, I thought this was a discovery. Let me see here.
no,
If I can get into,
So now they said that I was blocked too.
I think, yeah. It told me I was locked out and this I'm assuming is a e-file?
No, that one should be. Thought I read it.
It's actually not. I thought it was a discovery. We don't need that. I don't understand what this is. Okay, Mr. Johnson, you can come up here. Okay, on the record, in the matter of Lafview versus Esther Johnson, file number is 16-01493 GC, council appearance.
For plaintiff Lafku, Tim Smith, P 48259.
And your name, sir? What's your name?
Esther Johnson.
Okay, ma'am, what's your relation to him?
That's my dad. He's part of hearing. so
Okay.
I just try to help him out.
Okay, our device probably doesn't work, does it? Okay, we have a hearing device that never works.
Okay.
I'll try to speak loud. Does that help?
Yes, ma'am.
Okay, today's the date that's set for a motion, and I think the motion is to stop a writ of garnishment. Is that accurate? You filed a motion?
Yes.
You don't remember? He doesn't remember? Did you assist him?
Dad, you filed the papers, so you can help with the, so you can
Oh,
garnishment.
okay, yeah.
Sorry, he has a hard time with learning, like he has a learning disability.
Okay, does he have, are you like his payee or anything, or,
Mhm.
okay, is that a yes?
Yes, ma'am.
Okay.
Sorry.
Did you assist him with this paperwork?
I didn't, his niece did, I was at work at the time.
Okay,
So between me and his niece, we helped him, but he did come down with us to file the motion.
okay. Do
Or
you,
he did
do you
come.
know why you filed the motion to stop the garnishment?
No, ma'am.
You don't know why?
No.
Yeah,
Well, I stopped it because I don't even know why.
You don't know why you're getting garnished?
No.
Okay.
so he did file the motion.
Yeah,
Yeah, I know you filed it. I just want to know if you know why you filed it, because the reason that was stated here just says was asked to move and did move out, which is not a valid reason for a motion to stop garnishment. So I was trying to understand why you moved out. Mr. Smith, is this a garnishment for a tax, income tax?
State of Michigan, state income tax garnishment. We did get a disclosure back from the state of Michigan. They will be withholding, and that's what he probably received that in the mail, which is what prompted the response. It looks like he might believe that this has something to do with a landlord-tenant case, which this clearly is not. It was a debt that he has, a judgment that rose out of an account relationship with LAFCU.
That's what I see. I see a Lafview account that there was a judgment on.
Correct. The judgment was related to a Ford Explorer that he had financed through LAFCU.
Remember the bank that was taking the money from you? That's
For,
what
there
you
was a
said.
Oldsmobile vehicle?
Not for the loan. You gotta, that's what you really talk about. You gotta confuse. You think you're here for your eviction. You're here for this.
But why?
You can talk to them, Dad. I don't know. I'm here with you. He
Ma'am,
doesn't
number
understand
one,
why they're garnishing.
I don't know why I'm here. I don't know why they trying to take my money. That's what
Well,
I'm saying.
well, according to the file that I have, you had a debt that you owed to Lafview. You financed a Oldsmobile vehicle through Lafview. And they got a judgment against you. It looks like the vehicle was sold to offset some of that expense, and you still owe money to Lafview for that judgment.
And
Do you remember, are you able to tell him what year this was,
Yeah,
maybe, or what vehicle?
What year the judgment was for?
Uh-huh.
Well, I see here that he signed paperwork with Lafview, it looks like back on November 2014. For a 2003 Oldsmobile Aurora, a gray Aurora.
There were two counts to that complaint, Your Honor. There were actually two vehicles that were financed. There was a Ford Explorer, which is the That's Exhibit A to the original summons and complaint. Exhibit B is the Olds Aurora.
And the first one was what?
Judgment was entered, looks like
Oh,
October,
yep, I see a
July
Ford
of
Explorer
2015.
for Exhibit A. So there was two vehicles, a Ford Explorer, 2004 Ford Explorer, and then also an Aurora. And his signature was attached to this paperwork with witnesses.
You might remember in 2019, a couple years after the judgment entered, he and I met and we did do a creditor exam. He had a number of the same questions regarding what is this and why do I owe it? But I don't know if he remembers meeting me. It was in person, 2019.
I don't believe that he does. You remember meeting him before?
No, I don't.
Yeah, I think that, I don't know that he has any court orders allowing someone to take care of his business, but it sounds like you might want to do that.
In 2014, I didn't have power of attorney or anything like that. I didn't gain that until 2019.
Okay, so
But
you
he
are
didn't-
now his power of attorney.
Yeah, he doesn't own he never owned an Aurora. I know that for sure.
I'm not saying that he owned one, but apparently he signed as a co-signer, or he bought one for someone, because his signature is here as the borrower. And that was from November 2014.
Did you co-sign for someone?
Well, he signed, not co-signed. I'm looking at the paperwork. It says he signed for the 2003 Oldsmobile Aurora.
Ma'am,
Yes,
would that be from a car lot?
yes.
And would that the car lot that's on South Cedar?
Do you know what car lot this was? I see Sundance on one. I don't know if they both was purchased from Sundance. I don't know.
But the insurance company supposed to be taking care of Sunday.
Okay, well, they're still there. I don't know if the insurance company paid a portion or not. I can't speak to that, but you have a judgment. And so the judgment is rather old now. It's too late to attack the judgment, meaning appeal that judgment in this court. Right now, they're seeking to get payment on the judgment. And so there was a motion right here to object to the garnishment because they garnished your tax refund. Is that what happened? Do you remember that? Okay, so you have filed, or someone assisted you in filing a motion to stop that. The court rules only gives the court specific reasons as to when we can grant that. And you haven't provided me with one of those reasons, okay? So based on what you put here, which is that you were asked to move out and you did, that I can't grant that. I think you might have this confused. I don't know if you have a landlord tenant matter.
Yeah, like my niece came down and helped him file, so I think he was under the impression that he was coming for his landlord tenant matter and not
Okay.
the last key thing.
Okay, yeah, I don't have that matter before me today. Does he have a landlord tenant matter coming up?
I will for that.
Ma'am, if I bought,
425.
if I got a car back in 14, why would they wait 10 years later?
Sometimes it takes that and longer before they can get their money back. And when people owe thousands of dollars and because they don't pay it. So back in 2016, it looks like there was a judgment entered against you. Looks like for $8,736. That money wasn't paid. And so the money also accrues interest when it's not paid. And so look, judgment, actually total judgment, $8,913. That was signed by Judge Clark, okay? And so they've been trying to get the money on that judgment from you. Sometimes it takes that long for them to get it, sometimes longer.
Okay, I think I feel that. Does this mean to be-
Did you have paperwork?
She didn't even turn it. You never turned your, this in. Oh, I would have done it. I'm sorry. I work so much. I don't.
Okay, so I'm gonna have to deny this request. If you want to resubmit and request, you can assist him with that
I will.
down at the civil clerk's office, but this is an invalid request for to stop and a garnishment, okay?
Okay.
Mr. Smith, did I get a order already on that? I don't think I did.
You have not, and I don't mind if it's just an SCAO reason stated on the record is fine on my end.
Okay, sounds good. We'll do that.
Okay, thank you, Your Honor. Have a great day.
Thank you.
Can you tell me, how would I figure out about the Aurora situation? He's had plenty of Ford, so I'm sure.
You mean like which vehicle it is? When you go to the clerk's office, you can ask for a copy of the paperwork that's in the file, okay?
Mhm.
And then if she asks, make sure you ask for the complaint because Exhibit B to the original complaint is a copy of the contract with his signature.
Okay. Will do.
Yep,
Okay.
and that actually is in the file, the physical
Yeah.
file. Okay, thank you.
You bet. Thank you, Your Honor.
So that mean they're gonna take my tax money, right?
Unless you